Thank you. We move on in our program from the oceans to climate change. Well, as if climate change wasn't also affecting the oceans. But let's move to the Sustainable Development Goals first, especially Goal 13, which deals with with taking measures to address climate change, or taking urgent measures to address climate change and its adverse effects. And it's a great pleasure to have Professor Catherine Higham with us, I hope. Professor Catherine Higham is working at the Grantham Research Institute at the London School of Economics, and we've met the last time in Glasgow at COP26. It's a great pleasure seeing you again, and Professor Catherine will be speaking about SDG number 13 on climate change and its implementation. Catherine, the floor is yours.
Thank you so much. And I have to say also, although I'm very flattered, I should say I am not a professor. It's not a title that I can actually lay claim to. But I would very much like to thank you all for having me. And thank you to the speakers in this session and the previous session for what have been some really interesting and thought-provoking presentations. So I've been asked today to speak about the effectiveness of international and domestic law in regard to Sustainable Development Goal 13, which, as Christina has just highlighted for us, requires the global community to take urgent action to combat climate change and its impacts. My presentation today will be informed by my work at the LSE, where I coordinate the Climate Change Laws of the World database. This is a database that tracks domestic climate change litigation and legislation around the world. We now have more than 2,500 climate-relevant domestic laws and policies in the database, and more than 1,800 lawsuits globally. Now, I have to say that this presentation won't be about me introducing a particular legal indicator or set of indicators that give us the answer to our main question about the effectiveness of law in addressing SDG 13. And I also have to confess that until this excellent conference, I was not particularly familiar with the work that Professor Prieur has done on this issue. So I am very grateful to have had the opportunity to learn more about that and about how that work is being applied. And certainly it's given me some food for thought for future projects. What I do plan to do with the time assigned to me is to explain just a few of the different ways in which we can approach the main question with which we're concerned, and which I hope we can dig into in more detail during the discussion session. I'm going to talk then about three things. Firstly, I am going to talk about some pioneering work by colleagues associated with the Grantham Institute at LSE that seek to understand the impact of climate laws and policies on greenhouse gas emissions on a quantitative basis. And that research has been based on the Climate Change Laws of the World data. Secondly, I am going to invite us to think about a more purely legal avenue for understanding effectiveness through considering the exchange between the national and international legal orders on this issue, and thinking about the dissemination and diffusion of norms from the international regime to national regimes, particularly where they are directly enforceable by domestic courts, or where there are other oversight and accountability mechanisms that have been created. One of the things I'll focus on in particular here is the question of the introduction of legislated outcome-based quantitative greenhouse gas emissions targets and associated monitoring and reporting systems, which are an increasingly common feature in domestic climate legislation and also an increasingly common subject for domestic climate litigation. Finally, I'm going to think about some of the drawbacks that an overemphasis on measurable outcome-based targets may have when we are seeking to understand how effective climate law really is, or indeed when we are seeking to design effective climate change law and policy. So first, to talk about quantitative understandings of the effectiveness of climate law and the relationship of climate law to global greenhouse gas emissions. To put this into context, one of the 8 key indicators proposed for assessing progress against SDG 13 at the global level is the overall level of greenhouse gas emissions in the atmosphere. Similarly, the UN Framework Convention on Climate Change sets a goal of stabilizing greenhouse gas concentrations at a level that would prevent dangerous anthropogenic interference with the climate system. And I'm sure most of us are familiar with that goal. So the legal framework, the international legal framework on climate change has very much been designed in such a way that greenhouse gas emissions are the central object of governance, and their rise or fall is in many cases taken as the fundamental metric of success or failure. But there are many difficulties, I would say, in understanding the degree to which specific laws and policies at the domestic level may be considered to be effective in contributing to preventing an increase or even creating a decrease in greenhouse gas emissions. And some of those difficulties rest in the typical timeframes within which laws may become operational. They rest in the fact that many laws require additional measures for their implementation. There is a study by a few colleagues from some time ago that suggests that one of the key effects of climate change framework laws is actually the creation of more climate change laws. And a further difficulty can be found in the potential for confounding factors or causes to have played an even more significant role than legislation in changes that we may be seeing in levels of greenhouse gases in particular sectors. Despite these challenges, we have some colleagues associated with GRI that have recently made an effort to understand this issue rather bravely, in my view. And so 2 colleagues, Sheikha Stander and Sam Fankhauser, published a study in Nature in 2020, which seeks to understand the connection between national level greenhouse gas emissions and the global stock of climate laws. The authors looked at over 1,800 laws passed between 1999 and 2016, and they tried to determine if there was a statistically significant correlation between the passage of new laws and the overall greenhouse gas emissions intensity by GDP in a given country. They found that on average, each new law reduces annual carbon dioxide emissions per unit of gross domestic product by 0.78% in the short term, so that's the first 3 years, and by 1.79% in the long term beyond 3 years. So there is, of course, a lot that you can dig into in the methodology used in the study, including approaches used to control for the strength of the rule of law in different jurisdictions. And I won't get into the detail on that, as I'm not a political economist for one reason, but also because I think it's only one of the sort of ways that we can approach the question we're trying to think about. What I do want to highlight is what this type of high-level quantitative analysis can tell us and can't tell us about the effectiveness of climate change law. The study is useful because we can see there is some clear relationship between the passage of legislation and the impact on emissions. But we can't say which legislation makes the greatest impact or why. We can't say whether the influence of climate change framework laws, which are those laws that sort of set the strategic direction of travel for a country's overall action on climate change, rather than being sort of sector-specific measures or policies. We can't tell which of those 2 groups of laws have greater influence. One of the other key issues with the approach is that it necessarily looks at the impact of climate law in the past. So the study period was from the 1990s to 2016. What that means is that it can't tell us about the impact of some of the more ambitious laws and policies that are being passed now. And it also can't account for the fact that there may be some considerable lag or delay between the passage of a law and its full implementation or the achievement of more ambitious passages. So as Navroz Dubash has put it in a response to the study that was also published in Nature, it's a conversation opener rather than the last word in the subject. And I'm hoping it could be a bit of a conversation opener for us today. So another way then to understand the success of climate change law could be to focus on the enforcement of the norms from the international climate change regime at the domestic level. This is reflected in one of the global indicators of progress for SDG 13, which aims to understand the level of integration of climate change measures into national policies. However, for the time being, this has been assessed at the global level only on the basis of the number of countries that have signed on to the relevant international legal conventions, and not on the basis of operationalization, sorry about that one, interpreters, at the national level. So there's certainly scope to dig into this in more detail. And I think this is something that could definitely be done using the data in our database. Previous studies by colleagues at Grantham using the data have suggested that there is a strong growth in the number of domestic climate change laws and policies that are being passed at key points in the development of the international climate change negotiations. So there was a growth around Kyoto, growth around Copenhagen. The picture is complicated to some extent by the fact that this is a two-way exchange. So particularly between the years 2009, when we saw the Copenhagen Accord, and the Paris Agreement in 2015, that's actually when we saw more than 1,000 of the laws and policies in the database being passed. And there's definitely some influence of Copenhagen it being introduced in that legislation, but also legislation perhaps being introduced to give countries a stronger negotiating position in the run-up to Paris. There is but we can nonetheless take that as meaning that there is clear evidence that the international norms do impact domestic developments. And we can also say that in the first 2 years of the period in which the Paris Agreement was passed, we can see more than a quarter of the new laws and policies being developed in that time that make reference to the agreement or make reference to the nationally determined contributions that are required from countries under Article 4.2 of the agreement. We can also see this phenomenon at work in the way that emissions reduction targets, which are so central a concept in the architecture of the UNFCCC, have themselves now become a key feature of national level climate laws and policies. We're currently embarking on a new project around the assessment of national level climate laws and targets. So I can't provide full figures on this, but some very preliminary analysis suggests that there are nearly 200 domestic laws and policies in around 100 countries. So that's about 50% of the signatories to the UNFCCC that now contain quantified greenhouse gas emissions reduction targets. If we dig into this, we can see in recent years an even clearer trend of diffusion from the international to the national level when we look at the increasing prevalence of net zero targets or climate neutrality targets in domestic legislation, with more than 30 countries that now have such targets in national law or policy, meaning that 10% of global greenhouse gas emissions are covered by a legislated net zero target, and more than 40% are covered by a net zero target in a national level policy document. Now, the phrase net zero is not mentioned anywhere in the Paris Agreement explicitly. However, Article 4.1 of the agreement can be understood as translating this concept of net zero emissions, which had hitherto been a primarily scientific concept, into the legal and policy sphere. So for those of you who are unfamiliar with the Paris Agreement, and I know, of course, we have some people in this room who are very familiar with it, Article 4.1 reads, in order to achieve the long-term temperature goals set out in Article 2, parties aim to reach global peaking of greenhouse gas emissions as soon as possible, recognizing that peaking will take longer for developing countries' parties, and to undertake rapid reductions thereafter in accordance with the best available science, so as to achieve a balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases in the second half of this century, on the basis of equity and in the context of sustainable development and efforts to eradicate poverty. So it's this idea of balance between emissions by sources and removals by sink in Article 4 that has led to this focus that we see currently in discussions about climate change on this concept of net zero. And that's gained a huge amount of traction, both as a point of debate in national discussions and also among non-state actors. So what does thinking about this dissemination of norms and concepts between the national and international level tell us about effectiveness then? Firstly, it gives us a sense that international law on climate change is at least somewhat effective in advancing awareness at the national level. Secondly, we could say that the emphasis on measurable outcomes in the form of greenhouse gas emissions reductions also gives us an internal yardstick by which progress can be measured and a way for courts and other oversight and accountability mechanisms such as parliamentary scrutiny and transparency frameworks to say whether or not governments are complying with their fundamental commitments on climate. At GRI, we have started to look into this issue further, both in a recent policy paper looking at the number of accountability mechanisms in climate change framework laws, and in our ongoing work to track global trends in climate litigation. In that paper on accountability, we found that while nearly 50 countries have framework laws governing their climate action, few of them actually provide detailed provisions on oversight and accountability beyond transparency provisions, which are present in nearly every single law. There is therefore definitely significant scope to improve the clarity in the existing stock of laws, particularly as regards judicial review and parliamentary scrutiny. In our research on climate litigation, we find that there are almost 60 systemic climate mitigation cases that concern the level of ambition and the implementation of climate pledges and commitments that countries have made. This is a group of cases that we are looking into in more detail at the moment, and we plan to publish a study in April that gives us a bit of a stronger sense of what some of the key issues in these cases are, and whether we can draw out any kind of common threads. So certainly we've started a few bits of work on this issue, but I think there is much more to be done. Before I end this presentation, I'd just like to provide a couple of thoughts that we can perhaps get into in the discussion about whether the emphasis on emissions reduction targets and measures that I've just described is actually the best way to think about the effectiveness of climate change law. While I don't personally think that these issues are sort of fundamental reasons to question the current framework, I raise them here because I do think they're worth further exploration. So the first is an issue highlighted in a recent working paper by two colleagues, Fergus Green and Declan Cook. And I think this really goes to a point that I think it was Jan Aguila made yesterday about a very technical approach that we often see adopted in environmental law. Green and Cook question whether or not greenhouse gas emissions, which requires significant expertise to quantify, to understand, to estimate, and we know that many of those estimations are often inaccurate, should really be an object of governance, given that they are a full understanding of them is really accessible only to quite a small epistemic community. They suggest that there could be other ways to look at the success or failure of climate law and climate action and climate governance more generally, thinking about, measures that have been introduced specifically to address the causes of greenhouse gas emissions. So should we be thinking about effectiveness by trying to assess how many limits have been put on fossil fuel supply and use? Should we be trying to think about the effectiveness of measures to address climate change by thinking of whether harmful agricultural practices have been banned and whether those bans are being enforced? So I think there's a real interesting question there to think about whether there are some other ways that we could understand this issue. The second sort of point for discussion that I'd raise is a point about the sort of very nature of turning the achievement of a particular policy target, in this case, targets relating to the sort of specific levels of emissions reductions, into a legal duty. So this is something about which scholars of legislative design have expressed considerable concern in the past. And that often centers on the challenge of making a particular government body or minister responsible for achieving an outcome that will ultimately require action from a huge and diverse range of actors and a whole of society shift. And this is an issue that we're already starting to see entering into some of the litigation that's taking place around the world on climate change, with questions really starting to arise about what happens when these legal targets aren't achieved. And a step further, what happens when judgments requiring legal targets to be achieved are not actually enforced? So on that note, of course, we see two groundbreaking decisions from France recently, the decision of the Paris Administrative Tribunal in the case brought by Notre Affaire à tous and some of the other NGOs involved there, and the case before the Constitutional Council brought by Commune de Grand-Saintes. But we also see a number of kind of questions arising about how judgments that have been issued in other jurisdictions will be implemented. And in two of the perhaps most famous cases on climate change, sort of climate change action at a national level, a case brought in Ireland and the famous agenda litigation from the Netherlands, we're actually seeing the claimants talking about having to bring more litigation now because the judgments that were issued have not been adequately enforced by the state. So I'm going to end here. I hope I didn't go too much over my allotted time, and hopefully that will provide some food for thought for our discussions to come. Thank you so much.
Thank you so much, Catherine. I do apologize for the professor. It was somewhere in my speaking notes. Maybe it's just a premonition. Who knows? But thank you so much for your presentation. And I hope we have some time for discussions in the end. But your explanation of the travel of norms, both from the international to the domestic, but also domestic to the international level, is very fascinating. And I personally enjoyed your final two questions. They're absolutely relevant. So let's see if we can pick up on some of them towards the end of the session. Thank you so much for now. And our last but not least speaker on this morning session is Professor Gerd Winter from the University of Bremen. And in a very nice segue, I think, to what Catherine was just talking about, Gerd Winter will be talking about the assessing climate action of states by the use of the climate change action tracker or climate action tracker, which is a tool developed to determine the domestic or the ambition of domestic level action towards the global goal of keeping warming to well below 2 degrees or even 1.5 degrees. And the climate action tracker has even been used in some of the climate litigation cases that Catherine just mentioned. Without further ado, dear Gerd, the floor is yours.
Hello, everybody. Thank you very much for inviting me to this important event. It's really intriguing to look at the effectiveness of the law. It's a major theme which has been with us for many decades. So it's very much to the point to address this at a special conference. And there are various indicators measuring the climate protection performance of states. The most influential one is, I believe, the Climate Action Tracker. Its task is extremely ambitious, namely to indicate how the utilization of a global commons, the climate, is and should be shared between states. I will first characterize the instrument and then discuss its legal relevance. The Climate Action Tracker, acronym CAT, assesses the climate protection performance of states, applying 5 performance categories that correspond to 5 worlds of additional warming. The performance is rated sufficient, almost sufficient, insufficient, highly insufficient, or critically insufficient. The categories are differently colored from green via yellow and red to black. They correspond to 5 worlds of different warming, ranging from 1.5 to 2, 3, 4, and above 4 degrees Celsius. CAT proposes this rating for all. Let me see, I want to change the slide. Okay. CAT proposes this rating for all of those states for which data were available. Many states are already included, as can be seen from the world map. Simply put, the darker the color, the more insufficient the country's performance. So Russia is on the dark side, but some African states are yellow, so they are in the category of almost sufficient. And the UK also can be placed in that category. So the darker the color, the less sufficient the performance. 4 parameters are used for this assessment. 2 of them are descriptive, called policies and measures, and domestic targets. The other 2 are evaluative, called modeled domestic pathways and fair share target. Each evaluative parameter is applied to each descriptive parameter. Here, modeled pathways are applied to both policies and actions, and domestic targets, the same with fair share. CAT uses a more detailed template that combines all parameters. The example shows the template as applied to the EU. So you have here a panel concerning modeled domestic pathways, and here a panel guided by fair share. As said, modeled domestic pathways are prescriptive constructs. They are global scenarios of measures that can be taken in order to reduce emissions. They are based on hundreds of models concerning emission reductions from the main source sectors, including power generation, industry, transport, buildings, agriculture, waste, forestry, and land use, acronymed AFOLU. The pathways are grouped into less and more stringent ones, classified according to their impact on the said 5 warming worlds. Further on, the pathways are scaled down from the global to national levels. This is done by transforming the qualitative description into economic counting and ranging them in terms of cost effectiveness. This means that the measures are ranged according to their costs in different countries, and those countries are searched which can reduce emissions at least costs. A marginal price of avoiding a further ton of greenhouse gas emissions is identified, which still ensures the overall emission reduction required if certain temperature limits shall be respected. the price will be the higher, the lower the allowed temperature limit is. The marginal price found allows to determine what measures any individual state is expected to take up at that same price. This implies that some states, the developing ones, may need to undertake more mitigation measures because these are cheaper than if they were required by developed states. But the developing state will often lack the necessary financial resources. I will later come back to this disadvantage built into the cut method. Concerning our example, the EU, the model pathways are represented by the colored fields in the left panel. These here. For instance, if the EU wants to sustain an up to 1.5 centigrade warming world, it can still dispose of about 1.9 gigatons per year in 2030. So this is here, meaning emissions per year. This is the 1.5 modeled domestic pathway. Now concerning policies and actions, the cut parameter describes the real emissions from a state that are realistically expected for 2030. For the EU, about 2.6 gigatons per year are predicted for 2030. This is the blue dot here. Policies and actions corresponding to this quantity of emissions. This emissions level is then evaluated against the modeled pathways. Figure 1 shows once more for the EU that the policies and actions are situated within the 2030 2 degrees world, colored yellow, which cut characterizes as almost sufficient. Now concerning domestic targets, this is the second descriptive parameter. The domestic targets consist of the emission reduction target set by a state for an envisaged future year. The domestic target may also be submitted by the state as nationally determined contributions, NDCs. In the EU example, the target is a reduction to about 2.2 gigatons per year in 2030, the black dots here, which accounts for a 55% reduction if referenced to 1990. The domestic target is then evaluated against the modeled pathways and in effect categorized as located at the lower end of the 2 degrees world, the yellow range, and categorized as being almost sufficient. Now concerning the fair share temperature ranges, this is a prescriptive parameter. It builds on the global emission budgets that are available within the already mentioned 5 warming worlds. The global emission budgets corresponding to these worlds are then allocated to individual states. This is done by application of a number of principles reflecting fairness of sharing emission reduction burdens. Those principles can be grouped as shown in figure 2, including combinations. The application of those principles yields highly divergent budgets of states. This is easy to understand because, for instance, responsibility would factor in past emissions of a state, while present per capita would ignore this and distribute the present budget equally among states. CAT does not apply cost effectiveness in the fair share reasoning. This is here the principle, because it already plays out in relation to the model pathways. CAT avoids to decide on priorities within the remaining principles. Rather, it applies all of them together, which means that the state will dispose of a broad range of budgets because of the different distributional effects of the individual principles. These broad spans of applied principles are produced for each state and for all of the 5 global budgets. The result is fair share emissions ranges within the 5 temperature ranges you can see on this template again. So we have here the fair share ranges of an individual state. In sum, the rating of the EU performance is as follows. In view of the Paris temperature goals, the actual policies and actions and the domestic target will be in the up to 2 degrees world and is hence graded almost sufficient when evaluated against modeled domestic pathways here. But they are in the 3 centigrades range and hence insufficient when evaluated against the EU's fair share. There's thus the already mentioned gap of grading, which I will discuss in a moment. So we have here policies and actions. They are graded almost sufficient in terms of modeled pathways. But if we look up here, they are graded insufficient, leading to a 3 degrees world. So there's a gap in the final categorization. Now I'm turning to the legal framework. I will now address the legal framework, asking how CAT can contribute to its application and inversely be modified to even improve its service. This service is twofold. CAT enriches the facts and advises on the interpretation of the relevant law. I will focus on the Paris Agreement, although the international no harm rule, as well as national and international human rights, are also relevant. 3 components of the Paris Agreement are pertinent: the temperature limits, the allocation principles, and NDCs. I will treat them and add the final comment. Concerning temperature limits, the CAT works with global budgets as a start for sharing efforts. The temperature limits set by the agreement let me see here. Considering the CAT, these global budgets are taken as a start for allocation of the individual states. And it is crucial whether the agreement, the Paris Agreement, can be interpreted to legitimize this approach. Article 2 prescribes that the agreement side aims to strengthen the global response to the threat of climate change. Unquote. Quote again, including by holding the increase in the global average temperature to well below 2 centigrades above pre-industrial levels, and so on. The ceilings well below 2 degrees centigrade and efforts to limit to 1.5 centigrades are undoubtedly formal treaty law binding the contracting parties. Content-wise, however, lawyers have denied its binding character, reasoning that the temperature limits are just aims to strive at. Others, including myself, argue that while the article indeed starts with weak language, look at aims to strengthen the global response, it becomes definitive concerning one of the means, namely holding the increase below the limits. This is clear language, not relativized by any other concern. Only the ambition of the limits leave room for final determination, 2 degrees being the unconditional maximum ceiling. This means for CAT that it reasonably bases its fair share methodology on the temperature limits, and certainly when it uses the range up to 2 degrees centigrade. Insofar as it refers to 1.5 degrees, it goes beyond substantive binding international law. Assessments built on this are valuable but advisory in terms of international treaty law. They are, however, binding, I believe, if one includes fundamental rights in the range of legal requirements. It is by implication of the temperature limits that on their basis global emission budgets can be calculated, considering the uncontested correlation between greenhouse gas emissions accumulation in the atmosphere and global warming. Concerning allocation principles, the temperature limits can be pictured as determining the house within which the states have agreed to live. How much room the individual states shall be able to occupy is a question of appropriate allocation principles. As explained, CAT works with several of those principles. This raises the question whether those principles rest on the Paris Agreement. Its Article 2, Para 2, proclaims the most important ones, including equity, common but differentiated responsibility, respective capabilities, and different national circumstances. Some scholars suggest that this provision does not have much legal value, but it is there in the text, and that is more than if it was absent. Moreover, respect for the principles is set out in the grammatical form of indicative future. See the words. The agreement will be implemented to reflect equity, etc., which means it is binding. It is true, though, that Article 2, Para 2 does not decide about priorities between the principles, and in particular, not on how to factor in past emissions. I believe it is wise for CAT not to fill this lacuna with their own priorities. As explains, CAT applies all of the principles with the exception of cost effectiveness. But embracing all principles comes at the cost of rather broad ranges of fair shares. Alternatively, CAT could be reformed to detailing the fair shares resulting from different allocation principles. Now, concerning nationally determined contributions, Articles 3 and 4, Para 2 of the agreement transform the material obligations of emission reduction into an important instrument, the nationally determined contributions. They provide that each party shall prepare, communicate, and maintain successive NDCs that it intends to achieve. Several scholars understand NDCs to be completely voluntary, referring to the history of the instrument, which was a compromise to bring the large emerging states on board. But even though the NDC concept replaced the more ambitious but unachievable setting of binding reduction targets, this does not mean that the NDCs may be without any ambition. The Paris Agreement gives some substantial direction because NDCs must be designed side with the view to achieving the purpose of this agreement as set out in Article 2, unquote. Moreover, all parties, quote, will represent a progression over time, which adds a dynamic element to the principles that are to be applied. With regard to CAT, this means that CAT is right to not only assess policies and actions, but also domestic targets in view of fair shares. Now, a concluding observation. As explained, CAT evaluates domestic practices and targets, applying both model pathways and fair shares. There's one highly important result to be noted and commented: the gap between ambitious fair share demands and lenient demands by model pathways. This gap is typical for developed countries. Figure 3 shows how it looks like for the EU. The black horizontal dotted line, this one here, depicts the domestic target, see the black dot, which is graded as almost sufficient in terms of moderate pathways, left panel, but as insufficient in terms of fair share, the right panel. There's thus a gap between the two, which becomes even more drastic if the EU was to bring emissions down to almost sufficient or even 1.5 compatible. So going down to this level, which involves negative emissions as well. The gap is bridged by the gray bars, which the cut translates into obligations to financial support by developed for developing countries. Here, the gray arrow. Such support helps countries to pay for the emission reduction measures they are expected to undertake in terms of cost effectiveness, but are unable to afford. This discovery and handling of the gap is, as said, due to the application of the cost effectiveness principle, which is at the core of the model pathways. The Paris Convention does not count it among its allocation principles. It is therefore not a legal principle, but an economic advice. It provides a reason for making developed states to pay for their non-fulfillment of their fair share. On the other side, the systematic incorporation of cost effectiveness into the normative profile of climate law can be treacherous because it gives developed states reasons not to do their homework. The basic idea of the Paris Agreement, after all, is fair shares in kind, not in cash, meaning that states must do everything feasible in order to themselves reach the related emission reductions. Just one very final observation. It would be interesting to study whether a globalizing tool like the cut could also be developed for other environmental fields, such as, for instance, biodiversity. Thank you for your attention.
Thank you very much, Professor Winter, for your comprehensive overview. And I just open the floor for any questions, both here in the room or among the online audience following us. I currently see no questions. I do have one to you. Picking up on the last thing that you said, states must do everything feasible to reduce emission reductions. Now, you walked us through some of the provisions of the Paris Agreement that you identify as something that combines emission reduction ambition to the nationally determined contribution. Now, when we negotiated the Paris Agreement, there was one particular provision that aimed on linking ambition to the NDCs. And that is Article 4, Paragraph 3, which you did not mention, which states that parties, NDCs will represent a progression and highest possible ambition. And this was really put in there to link the ambition of NDCs to what parties feasibly can do. And my question is just, why would you not include this as one of the very central elements that are put into the Paris Agreement to determine their level of ambition? Because you're absolutely right, NDCs are not completely voluntary. There's guidance around them. And one crucial guidance is Article 4, Paragraph 3. And you didn't include it here. It was just something that I just wanted to ask out of interest. But anyways, I asked the audience to come up with some questions. Maybe while you answer, Gerd, we can think about further questions both to Kathy and Guillaume.
Well, I think progression is built into the very concept of CAT, categorizing states to apply insufficient measures means you have to do more. So there's an inbuilt quest for progression, I think. But you are right. I could have included this as well into my analysis.
The reason why I asked this is that there is a backstory to highest possible ambition. It was designed initially as a due diligence obligation. At some stage during the negotiations, it said in the draft negotiation text that states shall act with due diligence and accordingly apply their highest possible ambition to their NDCs. That changed over time, but the rationale remained, and it's an important ambition booster in a way that could be used to determine there. But it was just an interesting question. Are there any questions in the audience, in the online audience? Kathy, do you have any questions to Gerd, or vice versa? You're working on very similar topics. I wonder if you are inquiring about each other's presentation.
Yes, thank you, Christina. I found the presentation very interesting. I have spent some time looking at the climate action tracker myself. And I think one of the sort of major questions in my mind is the one that Professor Winter has highlighted really adequately. This question about, can we have the principle of equity manifest in an acknowledgement that developed country parties may not be reducing emissions as quickly as they should, but if they are willing to provide the sort of absolutely necessary and commensurate degree of funding to developing country parties, does that get around the problem? And this is something that I know has been a subject of some debate and discussion around the drafting of the European climate law. And that there are parliamentarians who are, willing to acknowledge that there is this problem, that the European climate law, ambitious as it is not sufficient to really achieve either 1.5 or a fair share reduction. And so what I'd be interested in is any thoughts that you might have on how domestic law could sort of adequately if we say there's an acceptable sort of exchange of cash instead of emissions reductions, what could be done to integrate that into domestic law in a way that there are safeguards around it? And I don't think that's a conversation that certainly I've seen had in detail, but I think it would be a fascinating one. So really interested in your thoughts on that, Professor Winter, and indeed yours, Christina.
Well, yeah, that's a really intricate problem, financial support. In an ideal world, financial support would be provided by developed states to developing states without a transfer of the saved emission quantities from the developing states to the developed states. That would be the ideal world, and something which is the fairest solution, I think, which also would reflect past emissions, the situation of the developed world, that it could only develop itself by using the entire Earth for importing energy with the implied emission of greenhouse gases. So that would be the ideal world. The practical world is such that the developed states want to have a transfer of saved emissions in exchange for providing financial support. That is realistic. But even then, there should be criteria applied in order to make this at least effective in terms of climate protection. And that leads to the criterion of additionality, which of which we know how difficult it is applied as in the clean development mechanism. But that would be core additionality. So if money is transferred for climate protection measures, they must be additional to what a developing country, had done anyway. So that would be. But I also have a question from my side to you, Catherine. I didn't know what your project, but it is very rich, I think, and I would like to know more. And you probably have a website where I can learn. But is it true that you did, just one tiny question here, that you did a correlation between the number of laws of the countries and if you do this, just to add my critical view here, if you do this, we come back to what was discussed yesterday, the problem of intervening variables. So if you have a result, the more laws, the less emissions. It could be that the intervening variable is corona or anything else. Yeah.
Yes, absolutely. Yeah. Absolutely. And so I wasn't a part of the study that was done using the data in our database, which is indeed available online at climate-laws.org, quite an easy one to remember. I wasn't involved in that study. It was conducted by some colleagues, but I think the point that you raise is absolutely a fair one. They did use a panel regression and try to control for some relevant variables in the study. And maybe I can put the link in the chat here for those who are interested. So they did try to control for variables using rule of law indicators, for example, to think about the sort of likely implementation of specific pieces of legislation in different countries. But I think you're absolutely right. We cannot use that study to say that it's an absolute truth that the number of laws relates to reduction in emissions. What I think we can use that study to say is there is a likely correlation, and one that we need to explore further to really understand and dig into the issue. So I think it's just the beginning of the conversation, really, not by any means the sort of definitive last word. I think it is something that we are regularly asked, can we attribute emissions reductions to legislation? And there have been some efforts to assess that on a qualitative basis, to understand how stakeholders understand a framework to have changed, investment decisions that are being made and so on. It's obviously much harder to link that directly to emissions reduction emission reduction targets. And it's also, I think, one of the reasons why the court cases that we're seeing now produce such an interesting set of questions, because, if we look at the case in France, where the case brought by Grand South, where the Constitutional Court, as I understand it, has said that the government needs to come back to the court with a set of measures that would be based on sort of estimates of their impact, would be adequate to achieve France's 2030 targets. There is a big question. What will happen if the government comes back with measures where the emissions reduction impact is estimated as sufficient, but it isn't sufficient because of sort of unforeseen factors that the government didn't take into account? Would the government then be in breach of a legal duty, or would they not, because the measures that they had decided to take were, as far as they could tell, were reasonably sufficient to achieve their goals? So I think it's a really interesting question with lots of facets that we need to dig into further.
Yeah, if I may add one remark, courts are often confronted with the argument, de minimis argument, where it is said, well, we only contribute to 2% or whatever to the emissions. And I think the cut mechanism can help here. The complexity of the allocation principles is very vast, very broad, but it is good to have calculations based on the different criteria in order to find out, and in a more complex way, what the share of a given country is. And this includes also the difference between fair share calculations and cost effectiveness calculations. I had a terrible time to understand cost effectiveness. It's very, very difficult. You need to be an economist. But once you are economist, you lose contact with the law. And cost effectiveness, the calculation of marginal prices, this to understand is very difficult. And I am very skeptical about this because the application of that principle results in a disadvantage of developing states. So my alternative would be that CAT should develop bottom-up expertise concerning individual states and asking them to do their best, technologically, economically, socially, state by state, go into the tradition and the possibilities of the states and come up with a normative result saying you could do this, and then only count the individual emissions which are still resulting from those efforts, sum them up and look at what world this would lead us. And this then can be confronted with fair share, but not cost effectiveness. But on the whole, my recommendation would be for court cases that you approach the duty of a given state to reduce emissions in a more complex way, and CAT can help here.
Thank you for this very interesting discussion. We've received one question in the chat, which I will read out, but we're also moving towards the end of the session. We had to squeeze in one more presentation. That's why we're going a little bit over time. But let me allow to read out the question from the chat. I translated it to English to make it accessible to me. The question deals with the Paris Agreement Implementation and Compliance Committee. And the question is, will the level of ambition in the NDCs be reviewed by the Paris Agreement Implementation and Compliance Committee? And does the committee have indicators, or does it need indicators to do that kind of review? And then there's a second set of questions which ask whether the ambition criteria are sufficiently precise and have sufficient normative legal meaning, or are they just basically free at the disposal of parties to determine?
I think the first question you are the best to answer, Christina.
Well,
could you do this? I don't know.
I'm happy to.
I don't know the answer.
Sorry. I didn't mention it here, but I am also the co-chair of the Paris Agreement Implementation and Compliance Committee for the last 2 years, and for most likely for another 3 years to come. And the fairly simple answer to the first question is that the Paris Agreement Compliance Committee does not review the level of ambition in NDCs. That's not part of its mandate, because it only looks at whether parties have provided an NDC or not when it comes to NDC. That's the legal obligation that parties have under Article 4, Paragraph 2. However, if a party by itself would like to approach the committee and ask for support in implementation, there is a possibility for the committee to think about how it could help a party to increase its level of ambition, but that's an unexplored avenue so far, but it's something that is open. So the committee doesn't so far have any indicators for assessing ambition, and it's not tasked to do it on its own. But in terms of the indeterminacy of the criteria, that's something I put back to you. Maybe you both have a final answer to that, and then we wrap up this session.
the Paris Agreement does not answer these questions. So it's an open, undetermined range of principles. But nevertheless, this is not new in legal context, that we have undetermined notions which still do say something. It's not without limits. So one can interpret them and apply different methods of interpretation. And of course, there's a difference between present per capita and past per capita. So past per capita is less easily to determine. How do you count the past emissions? But present per capita is very easy to do. Somewhat easy is also the criterion of respective capabilities. This is what I meant when I suggested that CAT should turn to a bottom-up country-specific studies. So do your best. We did propose this criterion also to the European Court of Justice in the Carvalho case, which was also called People's Climate case, that is related to fundamental rights reasoning. At the first step, you note that fundamental rights scope of protection might be violated, but the second step is then it could be that the violation of the right is legitimized by public interests if they are necessarily to be pursued. The necessary public interest test leads to capacity, leads to the makeability of climate protection. So there is a link to the law as well. So capability in the sense of these 5 criteria can also be interpreted with the help of other legal frameworks. And cost effectiveness does not appear in the Paris Agreement. So that's easy to answer.
Please, Catherine, you have the final word here in our panel.
Well, I won't add much to what has been said. Only to say, I think it's absolutely correct that cost effectiveness is not an easy criteria to sort of square with legal principles that we know are relevant in this context. So I would agree with that point. I think there is some really interesting work that has been done by many courts. So the Carvalho case is one, but also if we look at the decision in the Agenda Foundation case, for example, and in some of the other courts around the world that have kind of scrutinized the adequacy of domestic ambition, there have been a number of different approaches to determining what a state's sort of target should be. And in the Agenda Foundation decision, we find that kind of based in a range, and the court has chosen to say that there is a possible range within which the Netherlands could have assigned their emissions reduction targets, and they imposed a duty on them to at least do the minimum, which is what was then adopted by the state. So, of course, that is also something that then is somewhat problematic. If everybody does the minimum of the range that is acceptable to them, we still won't achieve the overall goals that we need. But I think that's the last thing I'd say on the topic.
Thank you so much. Thank you, Catherine. Thank you, Gerd, and Guillaume, who left his chair, but who was with us earlier. Thank you for this very engaging, very interesting discussion. We will break now for lunch. Please bear with us and join us again later. But for now, please join me in thanking you for your excellent contribution. Thank you.